Good morning, everyone. I'm Tom Bracken, President and CEO of the New Jersey State Chamber of Commerce. I want to welcome you to the third in a series of 5 webinars co-hosted by the State Chamber and New Jersey Manufacturers Insurance Group. These webinars will focus on key issues small businesses are facing today as the economy starts to reopen. I know many of you are looking at the risks of reopening and asking some very critical and crucial questions, such as what happens if an employee or a customer gets sick after visiting my place of business? How far can I go to accommodate employees' requests when they return to the workplace? Can I compel workers to get vaccinated against COVID-19 or wear masks before returning to the workplace? And what travel and telecommuting policies can I set for my employees? We hope to examine all these questions and others today with a series of guest speakers. After our guest speakers make their presentations, we will have a Q&A session. If you would like to submit a question, please use the chat box, and we will get to as many questions as possible during the hour that we have allocated. Ray Zardetto of the State Chamber will moderate the Q&A session after the speakers. I would like to thank our partner and sponsor in this series of webinars, New Jersey Manufacturers Insurance Group. They have been a great corporate partner of ours over the years and are one of the outstanding corporate citizens in our state. Now it is my pleasure to introduce Joseph Datro, VP Workers' Compensation Claims for New Jersey Manufacturers Insurance Group. Joe, it's all yours.
Thanks, Tom. I'm Joe Datro, Vice President Workers' Comp Claims at NJ Insurance Group. First, I'd like to thank the New Jersey Chamber of Commerce for hosting today's webinar. The Chamber has been a tremendous advocate for New Jersey businesses for over 100 years, and we appreciate their guidance and support. NJM has also conducted business in New Jersey for more than 100 years. And while we've endured many challenges since 1913, nothing could have prepared us for the COVID-19 pandemic and its storm of disruption and uncertainty. Throughout the pandemic, NJM has kept 2 basic questions on top of our minds. What is best for our employees and what is best for our policyholders? For the health and safety of our employees, we operated almost exclusively through a telecommuting staff with only essential personnel on premises in our offices. For our policyholders, we initiated a payment relief program for our commercial and personal insurance customers. We also refunded a percentage of premium payments to our policyholders. Currently, we have a plan in place that provides some flexibility for our employees to make a safe and gradual transition back to the office. In July and August, we'll have a mandatory 1 week in 3 schedule, meaning Group A will report the first week, followed by Group B, followed by Group C to ensure social distancing. In September, there will be a full return to the office with all staff working their schedules they did prior to the pandemic. Today's speakers, Melissa Salimbene and Lindsey Dishley, will talk in greater detail about the most pressing issues with employees returning to work. Among the topics they will discuss will be workplace accommodations, mask and/or vaccine mandates, employees' increased appetite to continue telecommuting, as well as employee travel policies. Once again, I'd like to thank the Chamber for coordinating this webinar series and bringing New Jersey businesses together to discuss these new challenges that we're all facing. On behalf of NJM, I wish you all great success and health in 2021 and beyond. And now I'd like to introduce to you today's speakers. Melissa Salimbene is Practice Group Leader, Employment Law at Chiesa, Shahinian Giantomaso, also known as CSG. Melissa is an experienced employment and commercial litigator. She represents employers in all aspects of employment litigation, including wrongful discharge, discrimination, harassment suits, whistleblower and retaliation cases, as well as wage and hour claims. She litigates in state and federal courts in New Jersey and New York. Melissa also represents clients before administrative agencies, including the Department of Labor and Workforce Development. In addition, she conducts internal workplace investigations for employers. Melissa is a 2001 graduate of Rutgers University and Rutgers University School of Law in 2004. Our second speaker is Lindsey Dishley, who is also a member of the CSG law firm. For her employment practice, Lindsey represents employers in all aspects of employment litigation in the state and federal courts in New Jersey, New York, and other local, state, federal administrative agencies. Lindsey graduated from Loyola University in 2005 and from the Fordham University School of Law in 2008. Now to begin this morning's discussion, here's Melissa Salimbene.
Thanks, Joseph, and really great job pronouncing our firm name. Very impressive. So you could call it CSG. If you can all just bear with me 1 second, I want to make sure I share my screen so you can see our PowerPoint. Okay, I think I did that right. Can everyone see that? All right. Okay. So, good morning, everyone. Thank you for that introduction. So I'll just jump into it. And, as you heard, Lindsey, my partner Lindsey and I are employment attorneys. So as you can imagine, a big part of what we've been doing the past year has revolved around the COVID pandemic. At first, about 15 months ago, we were inundated with COVID-related questions regarding reductions in pay and headcount, furloughs, sick leaves, and COVID-related employee accommodations that needed to be made. And things calmed down for a while, but now as the pandemic subsides and businesses are reopening their doors, we are once again being bombarded with COVID-related questions, but on the much happier topic of bringing employees back to the workplace and even increasing headcounts now that businesses are starting to grow again. So this is terrific news for all of us, but the return to the workplace in this new normal in which we are living also brings with it new challenges. So today we're going to briefly discuss, due to our time constraints, we'll briefly discuss some of the questions that Lindsey and I seem to be receiving on a daily basis. So specifically, we're going to talk about how to provide a safe workplace as we bring back our employees. Should we require masks and social distancing? Should we mandate the vaccine? Should we require employees to sign COVID waivers? That's a question I'm getting a lot lately. We'll also talk about different types of COVID-related employee accommodations that may need to be made, whether to require employees even to return to the workplace at all, or should we just let them continue to telecommute or do some sort of hybrid approach? And if we are, what do we need to think about if we're going to do that? What should our employee travel policies require? And then we're also going to talk about pay equity issues that we're seeing that are resulting from the pandemic. So getting into our first topic. How do we provide a safe workplace? So under the Occupational Safety and Health Act, OSHA, which I'm sure you're all aware of, employers are required to keep a workplace safe and free from recognized hazards. Now, the Federal Department of Labor recently issued some guidance on this, on how employers can comply with OSHA and mitigate and prevent the spread of COVID in the workplace. Now, here in New Jersey, the state has also recently provided some guidance as well. In fact, pursuant to recent executive orders 242 and 243 that were signed by Governor Murphy in late May, employers now may allow their employees to work maskless and not social distance, so long as those employees have been vaccinated. And New Jersey has ended its emphasis on telework. Now, when these orders first came out, especially when the first one came out in late May, there was a lot of confusion over them because the executive orders seem to impose greater restrictions on private workspaces that are not open to the public than public workspaces. So 2 days later, the second executive order was signed, which provided some clarification. So you really have to read these two executive orders together. And when you do, what they currently require in the state, and I stress currently because this stuff changes every day, but currently for indoor workspaces, so that are open to the public. So things like a retail store or a restaurant, something where members of the public are coming into a business's workspace. Effective as of May 28, fully vaccinated employees are no longer required to wear masks or socially distance. However, employees who are not fully vaccinated should continue to wear masks in these indoor public spaces. Now, of course, an employer can impose stricter restrictions if they want and require everyone to wear masks. Now, for indoor spaces not open to the public, so if you have a private business office where you're not having, customers and clients coming into your business space, the guidance is that as of June 4th, employers may allow their employees to work maskless and not socially distanced, again, so long as those employees provide proof that they've been fully vaccinated. Where an employer is unable to determine an employee's vaccination status or the individual is not fully vaccinated, employers must continue to require those employees to wear masks and practice social distancing in these indoor non-public spaces. So there's this weird distinction between public workspaces and non-public workspaces. And in the non-public, you need proof of the vaccination. I do want to note, because I think there may be some people on this call who are in schools or daycares, these exceptions, that there are some exceptions to the lifting of the mask and social distancing requirements. They do not apply to indoor childcare centers, summer camps, schools. The reasoning is that the vaccine still is not approved for children under 12. So today, if you're going to have an indoor daycare, summer camp space, anything like that, your employees are still required to wear masks. Now, like I mentioned before, here's the current rules in New Jersey, but an employer is always permitted to impose stricter requirements. So they can still require that everyone wear masks and social distancing. So you really need to determine what's the right thing for your business. You also have to keep in mind that these orders specifically state that employers may not prohibit individuals from wearing masks in these settings and shall not penalize or retaliate against anyone who elects to wear a mask. And I also want to note these orders also rescinded a portion of an earlier executive order that required businesses to let people work remotely if possible. So this means employers may call back their employees who have been working remotely. And a little later on, we're going to talk about what's best for your telecommuting policies. Now, a question I'm getting a lot. A lot of employers are asking whether the best way to provide a safe working environment is to mandate the COVID vaccine. So this is a tough one, and I could talk about this all day, but I won't because we don't have a lot of time. But employers are really struggling to determine what is the right thing to do for their organization. So I'm just going to talk about it briefly, but the questions are, do they mandate that all employees return to the office and get the vaccine? Or do they say, well, employees may return to the office, we'd love to have you back, but only if you're vaccinated? Or should employers just incentivize the vaccine, or do they just encourage and educate employees to get vaccinated? I want to stress that this is not something to rush into doing, and you really need to consider this, get legal advice, and consider not just the legal issues, but the practical issues as well. I was talking before the call with, the organizers, and I was saying how, I get this question a lot where I get an email, Melissa, yes or no, we can mandate the vaccine. And I say, it's not a yes or no, let's talk about it. And when we talk about it, a lot of people change their mind on what they originally wanted to do. So starting with the legal, the question is, may a private employer require employees to be vaccinated as a condition of continued employment or as a condition of returning to the physical workspace? So the answer is probably. We think so, but it's still a bit of a gray area. This is all very new. It's something we haven't gone through before. The EEOC has taken the position that employers generally may restrict workplace entry to employees who are vaccinated without running afoul of federal workplace anti-discrimination laws. So that's like the ADA and Title VII, or even the Genetic Information Non-Disclosure Act. However, in doing so, and the EEOC stresses this, employers must engage in the interactive process and consider reasonable accommodations for any employee who refuses a vaccine for closely held religious or disability-related reasons. Of course, unless an accommodation would pose an undue hardship on the employer's operation. So you still need to go through that interactive process for any employee who's going to say, I can't get vaccinated. Despite the EEOC's guidance saying, it's okay to do this, it's not going to run afoul of anti-discrimination laws, we're starting to see lawsuits pop up all around the country challenging employer mandatory vaccine policies. Now, most of these cases are in the early stages, so we don't know how they're going to turn out. A lot of them stress the fact that right now the vaccines have been distributed under the FDA's emergency use authorization only. So, we'll see how those play out. But we did just this month get a little bit of guidance in a decision from a federal judge in the Southern District of Texas, who upheld a private hospital's mandatory COVID vaccination policy by dismissing a lawsuit that claimed the COVID vaccine is experimental. So that lawsuit was a class action filed by 117 unvaccinated employees who were told, get vaccinated or you lose your job. Those plaintiffs argued that the hospital's requirements violated public policy, again, like I said before, because the COVID vaccines are distributed under the FDA's emergency use authorization rather than the FDA's usual process. Well, the judge disagreed, and in a very heated decision says that claim is false and irrelevant. The lead plaintiff is refusing to accept inoculation that in the hospital's judgment will make it safer for their workers and the patients in the hospital's care. And with that, the case was dismissed. So we don't know how that's going to play out. We don't know if that's going to get appealed. We also don't know what that means for New Jersey. That's the Southern District of Texas. But, it gives us a little guidance of where the courts may be going and that they're not going to accept the emergency use authorization argument. Now, besides the litigations that are popping up, another complication is that 15 states so far have signed legislation barring COVID proof of vaccination. There's similar legislation pending in New Jersey right now that, if passed, would prohibit private employers from asking employees if they've been vaccinated, requiring that they be vaccinated in order to gain entry, or requiring that they show proof that they've been vaccinated. So this is just pending. This hasn't been passed. Many think it won't pass, but it's just something, to think about if you're going to be rolling out a mandatory vaccine policy. So, based on all these uncertainties, if you're thinking about mandating the vaccine for your workforce, you should absolutely include your legal counsel in that conversation and make sure to have your counsel prepare written policies and procedures. Now, but putting even the legality of mandates aside, an equally important question is, should an employer mandate? You have to think about what are the practical implications? And there's a ton, but just, the biggest ones to think about is, if you're going to mandate, you need to be consistent in that mandate. You can't make exceptions, for your favorite employee. You can't make exceptions, here and there. You need to apply it consistently. So what are you going to do if you mandate it and 50% of your workforce refuses to get it and thus violating your policy? Are you going to fire them all? So that's something to think about. Or what if you just have one key employee who's not going to get the vaccine? I had a client call and say, I'm pretty sure my whole workforce is vaccinated, but our CFO isn't. And I know he's not going to get vaccinated. So, what would we do? Make an exception? And I'm like, you can't make an exception. But then what do you do if one of your leaders, he's not following the policy? So something to think about. A way to maybe get ahead of that is to do take a workplace survey and not an anonymous survey, just asking, are you vaccinated? Are you planning to get vaccinated? Or can you not get vaccinated? Something like that so you can see the numbers. I know a number of my clients have done that and have actually been really surprised with some of the results. Some finding out, wow, our whole workforce is vaccinated, not even an issue. Others finding out, oh, we have, several people, we don't know who they are, it's anonymous, but several who are refusing, will not get the vaccine. So something to think about. And another practical concern to think about is, if you do mandate, how are you going to do it? There's a lot of laws at stake here, things about record keeping, medical information you're now maintaining. It has to be kept separate from personnel files. How are you going to train your personnel who are going to be the gatekeepers and asking the questions about permissible questions? While it's fine to say to an employee, are you vaccinated? If they say no, your staff needs to know they can't say, well, why not? Because then you may be eliciting protected health information. Now, in light of these uncertainties with mandating, some employers are instead choosing to provide incentives to employees who get the vaccine, such as gift cards, cash payments, extra PTO. But there's some legal uncertainties in doing this as well. So that's something where you're going to want to consult your counsel. For example, like I said before, there's employees who for health or religious reasons cannot be vaccinated. And so those individuals may allege that your incentive programs are discriminatory because, oh, hey, everyone else gets, $100 gift card, but I have an underlying health condition and I can't, so I've lost this opportunity. So something you may want to think about. That could also have effects on employee morale. Also, monetary bonuses can carry wage and hour risks, because such payments must be included in a non-exempt employee's regular rate of pay when calculating overtime for the pay week in which the bonus was received. So that's, for those of you who have non-exempt employees, if they work overtime, you have to figure out what they made that week for figuring what's their rate for time and a half. And if they got this extra payment, that's going to mess all that up. So you're going to be creating unanticipated payroll expenses and additional administrative headaches. So is it really worth it? So what you can safely do without any risk is encourage your employees to get vaccinated and educate them. You can inform them about where they can get the vaccine, use promotional posters, flyers, advertise locations where the COVID vaccine is available and how to get an appointment. You could support transportation to offsite vaccination clinics. If you're able to, maybe host a clinic on site or team up with other businesses in the area to host a clinic to vaccinate your employees. Post articles and company communications like newsletters, or if you have an intranet or email about the importance of the vaccine and providing information. I've seen a lot of businesses inviting medical professionals to present to the workforce, and some have even been able to do that, through their health benefits plans to give information and education about the vaccine. Now, on to our next topic. Some employers that are concerned about being held legally responsible for COVID infections that arise in the workplace have asked if employees returning to the workplace can be required to sign waivers, releasing the employer from liability if the employee gets COVID in the workplace. My advice is don't do it. Such a waiver is not likely enforceable and may even end up being used against you. That the reason for this is typically the sole remedy for work-related claims falls under the state's workers' compensation statute, and workers' compensation claims cannot be waived. Now, although a workers' compensation bar doesn't prohibit claims for gross negligence or intentional torts, those are not waivable claims either. So a waiver is not going to protect you from those sort of claims. So even if there were some sort of applicable waivable claim here, a COVID waiver would still likely not be enforced based on public policy reasons. Courts often rule that the unequal bargaining power between an employer and an employee makes waivers unenforceable. Also, enforcing a COVID waiver would effectively allow an employer to just avoid its duty to keep the workplace safe and would require employees to assume the risk of working in an unsafe environment. So it's highly unlikely that a court is going to be willing to go down that road and enforce such a waiver. Also, waivers have practical problems. If you're saying to your employees, you got to sign this waiver, that may discourage your employees from returning to your workplace. Also, a signed waiver is not likely going to stop an employee from suing you. Rather, that signed waiver will likely be Exhibit A to show a jury that the employer was evading its duty to provide a safe workplace. So what should you do? The best bet is to implement workplace safety policies and procedures that ensure a safe work environment. Have written policies saying, these are what we're going to do with masks or social distancing or wellness checks. And you need to discipline any employee who fails to follow that policy. So if someone, lies on a wellness check, they check off that they have no symptoms and they're coughing as they walk in the office, have someone monitoring that. And make sure that you discipline anyone who violates that policy. When you circulate that written policy, instead of having employees sign a waiver, direct the employees to sign an acknowledgement that they received your policy, your safety policy, they read it, they understand it, and they will comply with it. Now, I do want to talk about some accommodations that will have to be made during COVID. So we already discussed the fact that if you're going to mandate the vaccine, you're going to need to accommodate employees who can't get the vaccine for disability or religious reasons. But even where vaccines are not being mandated, some employees are resisting the return to the work site and inundating human resources and employers with accommodation requests. I'm sure it's no surprise that the most popular request is to continue teleworking or working from home. Now, this is due to lingering concerns about exposure to COVID, particularly for those employees who have not been vaccinated or those who live with individuals who are not vaccinated, which would include those who live with children. There's still, some child care issues that are lingering. Also, employees sometimes just want to avoid the time commuting or maybe having to take public transportation and the concerns about getting infected that way. But I think the most common reason that people are making this request is the convenience of working from home. And some are finding better work-life balance, and many are also finding that they're more productive working from home. Now, in normal times, these accommodation requests probably would have been made over an extended period of time and trickling in. But now businesses are receiving them all at once when a target date for reopening is set. So as with all accommodation requests, employers need to make sure that they do what they've always done and handle each of these requests on a case-by-case basis, even if all of the requests are for the same exact thing, continued remote work. You may have to bring in more people to get involved in the review of the accommodation requests due to the number that you're going to be getting. But as always, the requirements are the same. You need to engage in the interactive process. And, the reasons why you may deny an accommodation request are the same as you may have in the past. So these reasons include if the employee does not have an ADA disability or a religious reason for requesting the accommodation. Employers have no obligation to accommodate an employee's personal preferences or beliefs, or their philosophical or political beliefs, or generalized fear in returning to the workplace. Similarly, childcare issues or health issues of others that they live with are not going to qualify as an ADA disability. So an employer doesn't have an obligation to accommodate these things, but you still are free to do so. So an employer may choose to accommodate, these other non-ADA reasons, but whatever they do, they need to make sure they do it consistently. Also, any accommodation must be reasonable and not pose an undue hardship to the business. So unlike in the past where you might have one-off someone asking to work from home, here the increased number of employees seeking accommodations may influence this analysis and the outcome, as granting work from home accommodations to one employee might not have been an undue hardship at all in your business, but granting it to the majority of your workforce might. So my suggestion is that before you reopen, share your policies with employees well in advance, give them, sufficient time to know when the reopening date is going to be so that your team, your in-house team, your HR team has sufficient time to process and assess all the accommodation requests. And finally, on that, just make sure you document. A lot of the COVID-related litigation we're seeing is due to a failure to accommodate. So you need to document that employee requested this accommodation. We engaged in the interactive process. We determined, yes, it's okay, or we determined, no, it's an undue burden on the company and we can't do it. Document it all and make sure that you maintain that documentation. So moving on to the next topic, telecommuting. So last year, we all pretty much jumped into remote work without warning and often without any written or even unwritten policies or guidance. Now, as businesses reopen and employers decide to maybe permit their employees to continue to work from home or work a hybrid schedule, employers need to take the time to prepare formal telecommuting policies. Some of the legal and practical issues employers will need to consider in preparing such policies include, who's going to be permitted to work from home? So work from home might be very workable for some positions and not for others. And that's a question I've had a lot. Can I say, these groups of employees, by position can work from home, but, this group that do this function have to be in the office? And you can, again, so long as you're consistent and you do it by, work title or position, not by any sort of protected characteristic. You also have to determine how non-exempt employee time will be tracked because you need to maintain those records of hours worked even when an employee is working from home. You're going to need to address how will equipment be provided. What's the employer going to provide and what is the employee responsible to provide? Is the employer providing a desk, a chair, computers, Wi-Fi, printers, paper, that should all be figured out in advance. You also need to consider workplace safety and workers' comp issues, because businesses are still generally required to record and report all work-related illnesses and injuries of employees, and are liable for work-related injuries, even when those injuries occur, at a person's home office. Also, businesses are going to need to ensure that they have workers' compensation insurance where their employees are actually working. Which brings me to the next thing about, well, where can employees work? I've had a lot of calls from clients saying, well, everyone's been working from home. So, we're a New Jersey company, but now I have employees in California and Florida and Texas. So this raises a lot of issues if you're going to permit your employees to move to other states. There's tax issues that are raised. And the big one is that a lot of employment laws issues come up because each employee is going to be protected by the employment laws in the state in which they are working. So that's where their home office is if they're working from home. So you're going to need to make sure that you're in accordance with all those state laws, which I can tell you is a major headache because every state has their own rules and their own requirements. I mean, even things like how often a paycheck needs to be given. You might be able to do it monthly in one state, but it needs to be every week in another state. So as soon as you have people moving away, you're going to have some problems. So, what I like to do in these policies is say, we're going to permit you to work from home, but you need to be available to be in the office on an hour's notice or a half day's notice or 1 day's notice, something where someone can't move to California, and be expected to get to the office for a 3 o'clock meeting. And finally, you need to consider workplace security and privacy issues. Make sure employees know that they're expected to ensure the protection of proprietary company and customer information, even when they're home. So if they're going to have confidential information on their desk, but then they're hosting a dinner party that night and people can come in and see it, that's going to be a real problem. People need to know that they have to put their paperwork away, shut down their computer, lock their filing cabinets. So other policies employers need to consider in this new normal include travel policies. So I'm going to turn it over to Lindsey to discuss that.
Great. Good morning, everyone. So as we are starting to bring employees back to the workplace, it's also coinciding with schools letting out, summer starting, and summer travel plans certainly on the uptick, especially after everyone sort of forewent their vacation plans last year. So what can employers do? And you really want to implement travel policies that at a minimum are going to require your employees to follow the coronavirus related travel guidance from the CDC. And to make sure that your employees are staying aware of these changes to guidance because it's ever evolving, as we all know. Similar to the policies Melissa mentioned, your policies can be stricter than CDC guidance, but you do want to implement written policies that at least advise your employees that they're required to follow the CDC guidance. And this guidance includes avoiding crowds, keeping social distancing, washing hands often, monitoring for signs of illness while traveling. And you might be thinking, well, New Jersey did lift their travel advisory. It's no longer in effect. But where this comes into play is the CDC does still have recommendation for traveling for vaccinated and unvaccinated travelers. So even if you don't mandate vaccines, as Melissa mentioned, the implications there, you want to make sure your travel policy includes that vaccination status may require post-travel precautions be considered before your employees go ahead and book that summer travel. Where this comes into play is not so much for your fully vaccinated employees, and that's because currently the CDC does not require your vaccinated employees to self-quarantine following domestic travel. And it really doesn't even require your fully vaccinated employees, depending on where they're coming from. Obviously, destinations, it varies by destination for sure, especially where there's some COVID hotspots. You have to check the CDC on this. But typically, it may not require fully vaccinated employees to self-quarantine upon return from international travel, so long as they have that negative test before boarding the plane and then take the COVID test within 3 to 5 days upon returning to the United States. Where this really comes into play, again, is for your unvaccinated employees who choose to travel. It's currently recommended by the CDC that you don't really get on an airplane until you're fully vaccinated. But to the extent your employees do, upon return from domestic travel, your unvaccinated employees should be required to either take a COVID test 3 to 5 days after travel and self-quarantine for 7 days, or if they choose not to take a test, to quarantine for 10 days. Now, similarly for international travel, obviously, again, it depends on where they're coming from and those specific requirements. But they would need to have documented either a negative COVID test or recovery from COVID before boarding a flight back to the US. And then upon return, they're going to need to self-quarantine for a full 7 days, even upon getting a negative test upon return, or stay home and quarantine for 10 days. So now you're running the risk as an employer of, you have an employee who just took a week-long, however long vacation, and now if they're unvaccinated, they're going to be required to quarantine at home. So you're going to want to have a travel policy in place that says if you're an employee subject to quarantine after travel, you either need to be able to work remotely during that quarantine period, or either you continue to use your pre-approved time off, whether it be vacation, or make alternate arrangements with either your supervisor or somebody else within the company. So these are just things you're going to want to consider. And again, travel related, to the extent it can be minimized during the pandemic, while we still sort of are in the tail ends of it, hopefully, the tail ends of it. Jobs also require travel. If you have employees who you really need to have travel for work, you as an employer, when it comes to business travel, may also want to impose some additional measures or take some additional steps to ensure you're protecting your employees while they are traveling. For example, to the extent you can look at the travel schedule and limit the distance to where your employees need to travel, there might be ways to minimize the need for overnight lodging and overnight stays. To the extent you can't do that and multi-day travel is necessary, you might want to coordinate with your travel preparers, whoever's booking reservations at hotels, to make sure you're booking at hotels that are regularly disinfecting rooms and sanitizing common areas, where you're providing the safest environment for your employees. You also might want to consider providing your employees with certain forms of transportation that minimize their need for public transportation. So you might want to have a car service or rental vehicles for your employees getting to and from airports or train stations. Also, if flying is necessary, consider booking direct flights that your employees don't have to get on and off of various flights. Also want to make sure that your employees are provided with any necessary supplies and understand protective measures they can take while traveling, which includes the distancing, the masks, disinfecting wipes. You might want to consider ordering food in for your employees as opposed to having them go out to restaurants. And just make sure your employees know that if they get sick, they should stay home and not travel, even if it's for business, and to make sure that they know who to notify if they do get sick during the course of their travel. So just some additional considerations now that we're starting to be on the move again from hunkering down over the last several months. Another topic, Melissa, if you want to move to the next slide, that I just want to touch upon that I have found fascinating, and I'm actually also want to raise it because I am starting to see an uptick of these types of claims as an add-on to other types of claims that employees are raising. And this involves New Jersey's DIANE B Equal Pay Act. And the reason why I think this is so fascinating right now and is so important for employers to have at top of mind is because it's really the intersection of two critical things that happened out of 2020. It's the uptick of DEI, diversity, equity, inclusion initiatives, as well as obviously COVID-19. And as much as COVID-19 obviously has been a very difficult situation for everyone in a multitude of ways, when referring to employment, the statistics really do show that overall, women and minority workers have really been disproportionately impacted by COVID-related either unemployment or layoffs. And the reasons are varying. A lot of the industries that had to shutter their doors are industries that did have employment more heavily concentrated by women and minority workers. Additionally, COVID-related school closures disproportionately statistically impacted women who were forced to come home with their children. And a lot of schools really just started opening, so this is still impacting women. And statistics do show that the income and the layoffs have been definitely disproportionately impacting those minority and women workers. So now as schools and businesses reopen, these women and minority employees are returning to the workplace. So as they're returning as employers, we really need to be sure we're complying with this Equal Pay Act. It became effective July of 2018, and it's an amendment to the New Jersey Law Against Discrimination. So just a little background on the act. It generally applies to all businesses in New Jersey with at least one New Jersey employee. And what it does is it mandates that employers compensate employees within any of the protected categories under the LAD, which are a multitude, at the same rate of pay as non-protected employees who perform what they quote, substantially similar work. So there's only very few defenses to not paying all your employees in protected and non-protected statuses the same. And those are if you have a seniority system or a merit system, or if you can meet a 5-part test to show that your pay differential is based on legitimate bona fide factors. And that could include specific training or experience or education, or some sort of quantity or quality of your employees' production. So, and a lack of intent to violate the law or a lack of knowledge of the law is not going to be considered a defense to paying all of your employees substantially similar amounts. And in addition, the act further prohibits you as an employer from considering an employee's salary history in determining pay or asking about salary history. So the reason why this is becoming so important, especially with the act now being almost 3 years old, is that the statute of limitations for the act is 6 years, where normal violations of the LAD are 2 years. So the look back period of these violations could be getting, more and more substantial as we get further along, which is what's becoming so attractive to the plaintiff's bar here. And this is because in each instance of any wage or other form of compensation found to be paid in violation of the act can entitle the employee to not only the compensatory damages, their attorney's fees and costs, but also treble damages in the amount of 3 times of any pay differential that cannot be justified. And when I say that the pay differential, when you're saying, well, this person's more senior than this person, you need to justify every amount of that pay differential. Not any part of it can be based on any sort of protected category. So for small businesses and small employers, this could be crippling to you, especially even trying to defend against these claims where you have to then justify and go through your pay records to show why somebody was being paid differently. So this can be a really devastating mistake for employers. Another consideration is the fact that compliance with the act is just better for employees and employers all around. Studies have shown that equitable workplaces lead to an increase in morale and job satisfaction and productivity. It can really improve your organizational performance. And with regards to morale, if your employees feel like they're working in a more equitable workplace, there is going to be less turnover and less likely chance that you're going to have those complaints of discrimination and headaches. So moving on to the next and last slide, what do you do as an employer to ensure compliance with the act? There's several things you can do, and they're certainly worth doing, especially proactively to avoid a potential claim that certainly could be, as I mentioned, just financially devastating. The first thing to do is to review and update your job descriptions. You want to make sure that they're clearly articulating what each employee is actually doing so that you don't run the risk of employees doing drastically different tasks, having these generic job descriptions where they could later say, well, we were performing substantially similar functions, and now you can't really defend against a lawsuit because your job descriptions really tell a different, even if inaccurate, story. Another thing we highly recommend is that you conduct an audit proactively and do so to the extent you can with the guidance of counsel, because that's your best chances of keeping the audit confidential. And what you're going to do with an audit is you're going to look at salaries and benefits, because both are included in the analysis. to ensure you are paying employees performing substantially similar work the same, or make sure you can justify those differences in compensation, as I mentioned before, based on differences in training or productivity. And remedy proactively any potential violation that you might see so that you can mitigate against any potential violation. I would recommend when you decide, if you decide you need to make some adjustments, you're always going to adjust the employee making less money up to meet the employee making the higher salary, not vice versa. And to the extent you can, to not, draw any attention to the issue, to the extent you can make those increases when you're making annual increases anyways, you're obviously going to be better off doing that to the extent that you can. So in addition, you want to mitigate against future concerns or future issues arising where you might run into potential future violations. And you're going to do that by either reviewing or creating for the first time salary and benefit policies. You want to eliminate the discretion and negotiation of salaries that tends to happen in smaller businesses, right? It's a regular practice. You have managers using that gut check of this person's doing a good job, I think they deserve a raise of X amount. There might be some unconscious bias going on there. So you want to have more objective criterion as to what is going to be used when making salary and benefit determinations. And this is determinations upon hiring, as well as increases, bonuses, and raises during the course of your employee's employment. Having this defined criteria is definitely going to minimize your concerns of discretion and negotiation, leading you astray and into potential violations. Some of our clients have actually chosen to establish salary ranges, and each position is designated a number that associates with a salary range so that it's transparent to employees that if you are at a certain career level, you are going to have a pay within a certain grade. It's going to really give a minimal band where there's no negotiation, and it's very transparent that this employee is making within this range and it's not arbitrary. So just like other policies, once you have them in place, you want to make sure you're applying them consistently and training your employees on these policies to make sure your management is applying them consistently and being sure that their decisions are on this objective criterion. You also want to make sure your employees who are making these decisions are documenting their decisions and their basis for each salary decision. And again, this includes initial salary offers, as well as annual raises and bonuses. This becomes particularly important because of this 6-year statute of limitations. If you have a manager who's made a pay decision and then they leave and then you're faced with a lawsuit, you want to make sure you can go back to that documentation as your defense to justify why maybe one employee was making, more than another employee because it was based on production or is based on, they had an extra certification, things of that nature. So it's really important to have remaining managers be able to understand a justification of a predecessor so that you do have a proper defense in place. So really, it's just another consideration that's a little peripheral, but I do think it is certainly, as everyone's coming back to the workplace, make sure you're doing it right from the get-go as you're hiring and making these decisions. So I know we threw a lot at you on a lot of different topics, but thank you so much. And we are open to questions.
Well, thank you, Melissa. And thank you, Lindsey, for a lot of information. There's a lot to digest, a lot to think about. So I did get a couple of questions done. I'll try and get to as many as we can in the time we have remaining. So one of the first ones I thought is sometimes precedent is so important on these things, but is it possible that liability related to the COVID-19 infection will or could become precedent for other infections or medical conditions such as the flu, and that we might see litigations like this for those kinds of medical conditions down the road?
I think it's possible. I think COVID is a very different thing. So, really a lot of the litigation we're seeing right now is not related to I got COVID in the workplace. We're seeing a lot more of failure to accommodate or discrimination claims because someone got COVID, or somewhere someone couldn't come to work because they have an underlying medical condition. We're seeing more of that. It's same thing with like the mandate. I know it's been asked also, like if we mandate the COVID vaccine, or are we going to see businesses mandating flu shots or other sorts of vaccines? It's possible, but I think everyone is different. Even things like the flu shot, if you mandate it, you have to make a lot more exceptions. It's a different sort of, I won't even pretend to know about the science, but it's a different sort of vaccine. Those with like egg allergies can't get the flu shot. So, you'll still have to go through the process of accommodating. But I don't think that people should be afraid of, what's going to happen down the road just because we do something with COVID. I think right now, COVID is a very unique circumstance.
Okay. In fact, it's so unique, and I know how much legal thinking relies on precedent. Are you aware of any precedents at all relative to what's going on with COVID and the issues around that and what employers have to face? You aware of any such precedents prior to this?
It's so hard because, you have to go back to what an employer needs to do, and they need to provide a safe work environment free from hazards that can cause serious injury or death. Right. So there's not a lot of things that are spread that can do that. So, if you're going to do, and to go back sort of like to the flu, like if the flu spreads at the office, is that going to result in death or serious injury, or is someone just going to be out a few days? If someone gets a cold, are they going to be, is that a serious threat of, serious injury or death? So that's what you really need to look at. You don't have an obligation as an employer to provide a workplace where no one's ever going to get a cold or sick. You just need to do your best to make sure it's free from those serious hazards. So I don't think we've had anything like this before. I know we were talking before the call about, the last pandemic was, 1918, and we didn't have any of the employment laws that we're worried about today. These are all relatively new. There was no, anti-discrimination laws back then. So it was a different world. So I don't think, we have anything like this. And even with the the vaccine, it being currently emergency use authorization, that's a new concept as well that we haven't really had to deal with. So it's a new world, and it's a new normal we're living in. And that's why, anything you do now with opening up your business again, I think you really need to think it through, talk it through, engage legal counsel, and think about, again, not just the legal, but the practical implications of everything.
So if we are entering a new normal, then one of the questions that comes to mind is, assuming this pandemic, we get a handle on it, it looks like we are, but you never really know, but assuming we get a handle on this pandemic and things begin to come back to this new normal, as you describe it, how long do the issues of COVID liability linger? 2 years from now, could somebody sue for something that, if it did happen or has happened, that they can relate to getting COVID at that point? How long does this go on?
I literally had a client ask me that yesterday. I don't have a crystal ball, was my answer. That client has a retail store and is trying to figure out what to do with the masks. And does he have his, staff masked? He really doesn't want to have anyone masked. And he's like, how long? Like, what's going to happen? I don't know. I think it's going to last a while. I think one of the biggest issues is that, we're still seeing people getting vaccinated. Not everyone's vaccinated. And the fact that the vaccine has not been approved yet for children 12 and under, or under 12, I think is a concern. So that's still a lingering issue out there. So I think that it's not going away anytime soon. It's certainly getting better and improving, but I don't think that, in a year from now, everyone can say, all right, we're good, nothing's going to happen. And also because, there is a statute of limitations for these claims. For the employment cases, if you do something today, in 2 years from now, you might get hit with a lawsuit. So if you don't accommodate someone right now for a COVID related issue, you may get hit with a lawsuit in 2 years. So it's not going away anytime soon. I think it's something we just need to live with right now and make sure that we're addressing properly.
Okay. Let me squeeze one more in. We're almost at the top of the hour. Let me squeeze one more question in here. Can an employer be held liable if an employee who contracts COVID-19 at the office and then spreads it to anyone else, friends, family, or neighbors or whatever, can the employer be held liable for that?
So an employer can be held liable for not providing a safe workplace for their employee. So if an employee comes to work, gets COVID, comes home, their spouse gets COVID, could that spouse sue the employer? I mean, anyone can sue anyone. Are they going to be successful? I would think not likely, because the obligation of the employers to have a safe work environment for its employees and those entering their physical workspace. So I think they'd have a difficult time, that spouse who had never set foot in the workplace suing that workplace and recovering for that. But if I was in law school right now taking a torts exam where you sue everyone you possibly could for any sort of injury, I mean, yes, the employer would be named, but I don't think that's a real concern. I think the concern there is the employee suing. The employee saying, I went to the workplace and I got COVID there. But again, it's not just, if you, employer, are doing everything you're supposed to do, if you have policies and procedures in place, you're doing wellness checks, you're requiring the masks and social distancing for your unvaccinated employees, if you're following everything consistent with the law and doing what you need to do, then they're going to have a really hard time suing you because they got sick. They may still get sick, but if you've done what you've done and what you're supposed to do, and someone comes to the office and lies on their wellness check or was asymptomatic and still causes the spread, you're probably not going to have any liability for that because you did what you did. But if you make that exception and say, well, you're the boss, you're the CEO, and you're clearly sick, but we're going to let you come to work today, and then it spreads, then you're going to have a problem.
Okay. Well, it seems like common sense should rule the day in a lot of these.
Yeah, but you'd be surprised.
Yeah, I know. That's easier said than done. I know. Yeah.
Exactly.
Well, we're just about at the top of the hour now, so thank you, Melissa. Thank you, Lindsey, for all this information today that you shared with us and for your time. And for everyone on the call, there will be a replay of this webinar available beginning tomorrow. And we'll also send, with a notice about that replay, a link so you can get these visuals that Melissa and Lindsey shared with us today. You'll be able to access those. Also would like to take a moment to thank again Joe Dotro and New Jersey Manufacturers Insurance Group for making today's webinar possible, and also the series of webinars that we're presenting this year. We have 2 more to go in this series. They'll both be in the fall, and we'll be sending more information about both of them over the summer to everybody. So look out for that information, and thank you for joining us today, everybody. Have a great day. Thank you.
Thank you. Goodbye.
Bye.